Welcome back, Black Belt family. So there have been lots of questions following the Johnny Depp verdict in the United States, and I'll try to address some of those here, but some of those questions are so big that they warrant their own video. Lots of those questions revolve around the UK decision. For example, whether the verdict has any impact on the UK decision. Secondly, what happened with the UK decision, given that a jury has now found that Johnny Depp was right and telling the truth all along? Well, I will address some of those briefly in this video, but there will be a big teardown of the UK decision in a separate video, so make sure you subscribe to receive that video. Now, the first question answered really is that this jury verdict is not going to have a direct impact on the UK judgment, for many reasons. First of all, the normal route of appeal has been exhausted because permission to appeal was refused. And there's a number of reasons for that as well. Because in the United Kingdom, and I can speak to England and Wales because I'm a barrister practicing in England and Wales, the appeals process is actually very difficult. It is difficult to obtain permission to appeal, which you need before appealing a civil decision. In criminal cases that are tried in the magistrate's court, you have an automatic right of appeal to the Crown Court, but that's separate. We're talking about civil trials here. So you need permission to appeal before you can actually have the appeal heard. And the appeal is ordinarily not a rehearing in a civil trial. It is more a review of the decision, and it is usually looking to whether there was an error of law or error of procedure. It is ordinarily not going to admit new evidence that was not before the court in the first instance. And even if permission to appeal is granted, the appellate court is not going to just impugn the judgment of the judge when making decisions of fact in the original case. As I said, it's looking more towards law and procedure and whether there is errors of law or procedure. For example, if evidence was considered that should not have been considered, or vice versa. I do have some personal views on the UK judgment and how that decision was arrived at, and whilst I am not quick to criticise the courts and judges, certainly not a High Court judge, I do feel that there were some standards applied to one party and another that was not very consistent, and I will explain that in full in another video because it was a lengthy judgment. It was 129 pages long, and there are lots of different elements of how evidence should be applied, should be considered, and I feel that all the way through it was coming down on one side, and that being of Amber Heard. But as I said, that will be a full teardown in another video, so make sure you subscribe for that one. So the short position is the US verdict is not going to directly impact the judgment in the UK. However, since so many of you have asked the question whether it is possible at all to reopen the case in the UK following the US jury verdict, I would just like to explain very briefly here that there are one or two avenues to do so. Part 52.30 of the Civil Procedure Rules provides for the reopening of final appeals, which includes permission to appeal. Now, it's a very difficult hurdle to overcome because this sets out that the Court of Appeal or the High Court will not reopen a final determination of any appeal unless it is necessary to do so in order to avoid real injustice. And the circumstances are exceptional and make it appropriate to reopen the appeal, and there is no alternative effective remedy. And subsection 2 provides that this does include an application for permission to appeal. So this does beg the question as to whether or not Johnny Depp's lawyers are going to look at this particular part of the Civil Procedure Rules to bring fresh evidence on the basis that the jury has found very differently to the judgment in the UK, having heard what I would probably suggest as more evidence than the court heard in the UK trial. There is also the well-established route of bringing fresh proceedings to upset the judgment on the basis of new evidence, which would usually look to fraud or perjury or something like that. Again, a subject to be looked at in another video. And like any other litigation, this is not a decision to be taken lightly. That is because when you think about these rules, our civil procedure rules, you can think of it very broadly as the court always retains discretion, just as with costs, which is another question that I'll come back to in just a moment. So our courts always retain full discretion over costs, full discretion over orders, full discretion on how to hear evidence, which is a very important thing which comes into play with the UK judgment. In other words, the judge in that case had the power to decide how evidence was heard, how it was considered, what weight was placed upon it, and therefore arriving at the decision. Circling back to the appeal just briefly again, when permission to appeal was sought, the appellate court looked at how the decision was arrived at and whether the judge gave reasons for that decision and reasons for finding of fact as he went along. And that he did so, although there are lawyers that believe that he didn't provide sufficient judicial reasoning to come to that decision. But nonetheless, the appellate court would not impugn his judgment on how he reached that decision because reasons were given within the judgment. As I said, it was a 129-page judgment, so certainly not light bedtime reading. But nonetheless, there is also another reason why the UK case is distinctly different from the US case in terms of the verdict and the decision, and that is who the defendants were. Now, there's a very interesting section of Amber Heard's statement that she released. Now, the significant and important difference is this. In the US trial, Amber Heard was the defendant. In the UK trial, there were two defendants, and those were News Group Newspapers Limited and Dan Wootton, the then executive editor, who actually wrote the article which was the substance of the claim in the first place. So just if you missed it, the defendant was not Amber Heard, and that had a significant impact for our disclosure rules. What in America they call discovery is broadly the same thing, is looking and searching for documents that could assist or hinder either party's case, and there is a duty to disclose, to make known any of these documents or any of this material that could impact or hinder the case. Now, as I said, in the UK trial, Amber Heard was not the defendant, meaning the ordinary rules of disclosure did not apply to her. There were applications for what is called third-party disclosure, because Amber Heard, although this was all about her and Johnny Depp, she was a third party to the claim in the UK. So there was an application for third-party disclosure from Amber Heard as a third party, but that broadly was refused. So some evidence did not make its way into the UK trial, but in the US trial, that evidence, no doubt, made its way into the trial and thus was all before the jury. But the interesting point is this. In the statement released by Amber Heard on Twitter, reading from that, she says, "I believe Johnny's attorneys succeeded in getting the jury to overlook the key issue of freedom of speech and ignore evidence that was so conclusive that we won in the UK." Noting the wording that she used here, we won in the UK. Now, she didn't win anything in the UK because she was not a party to the claim. She was not a defendant, she was not a claimant, so she didn't win anything. In fact, it was News Group Newspapers Limited and Dan Wootton that ultimately successfully defended the claim in the UK, but on a very different basis because, as I said, I feel the evidence was limited in the UK trial, and I believe there are issues with how the judgment was reached, but as I said, I'll come back to that in another video. Now, some people on social media have speculated, I'm not going to comment as to the factual basis or factual truth of any of these, but some people have speculated that there was bias from the judge and connections with News Group Newspapers Limited and or its employees. Now, if there were such bias within that case, ideally the judge should have recused himself. In fact, there is a significant document which is the Guide to Judicial Conduct, whereby if there are connections between the judge, be that family connections, familial connections, business connections, monetary connections, and so on, then the judge ought to recuse himself from the case. As I said, I'm not going to comment on any of the factual basis because I've not looked into it and I don't have any factual basis for any of that, but suffice to say, some people do draw those connections. Now, I will also say on this point that it is not unusual for a judge or a barrister or a lawyer to know someone else on the case. In fact, there might be two barristers on one case on opposing sides from the same chambers. That's not unusual. In fact, quite the contrary, it's quite common because the bar is a small place. There's only around 17,000 barristers and only around, I think, around the region of 150,000 solicitors. So when you boil that down to the cases that are heard in court, it's quite likely that barristers are going to come up against each other on the same case, and even fewer judges. And those judges are likely to know the barristers in the case because, again, the Bar of England and Wales is particularly small. So doubtless, most judges are going to know at least a significant chunk of the bar, members of the bar, and so knowing someone else is not unusual, and that in and of itself can't be seen as bias. That's not to say there aren't other links there that some people could look into, but I'm not doing that in this video. Next is the question of costs. Now that Johnny Depp has won the trial in the US, some people have asked, now does she have to pay his costs? Well, the ordinary rule in the United States is in direct contradiction to that in the United Kingdom. In the United Kingdom, we have loser pays the costs as a default rule, unless there's a reason otherwise. In the United States, in America, they know it as the American rule, which is the complete reverse. You pay your own legal costs and the other party is not ordinarily responsible for them. There are some exceptions. Those are usually contractual exceptions. So if you are under a contract and there's a dispute and you lose, then you might be contracted to pay the other party's costs. And I suspect that there are others, such as state rules or laws that require you to pay those costs, or potentially in a case of fraud, if someone is found to be fraudulent, then they might be forced to pay those costs yet again. Some of you guys have also asked me to comment on the lawyers themselves. Now, again, I'm not quick to comment about other lawyers. I'm certainly not quick to criticize other lawyers, but I did notice certain smirks and smiles and what I call a smile of contempt, which is one side of the mouth raising as a sort of contemptuous smile. I did see some of those throughout the trial from Amber's lawyers, and I find that somewhat unprofessional, and frankly, I just don't like it. There were also some questions aimed at witnesses, which I didn't really like as well. So we have rules, and I'm sure they have rules in the United States, and I'll be sure to ask Alita from Law Bites about her views on this. There must be rules about not asking a question which is solely designed to annoy, intimidate, or humiliate a witness. Members of the Bar of England and Wales cannot ask a question in cross-examination which is solely designed to annoy, to intimidate, to ridicule, to humiliate a witness. It must serve a purpose. It must be something that they can answer. Of course, they must answer the question. They cannot simply refuse to answer the question. The judge can order them to answer the question, and if they don't, they can be held in contempt because they're required to answer the question. However, one such question from Elaine, Amber Heard's lawyer, to Mr. Tremaine, stating that this gets you your 15 minutes of fame. I don't think that helps the case or the evidence in any way whatsoever. In one very narrow sense, you could say that she was trying to undermine the reliability of his evidence, saying that he's only here to give evidence because he wants this 15 minutes of fame. But I don't think that was a fair question. I don't think that was a professional question, and I don't think that question should be allowed. And quite rightly, it was interrupted. And in fact, his response to that was a very natural response. He said, well, I could say the same about you, because that was his response to the lawyer. That's how he genuinely felt. So personally, I don't believe that he was there for any kind of fame whatsoever. As he said, it somewhat puts him in the firing line for coming out and saying this in the first place, because journalists are known for not giving up sources, not giving up tips, not giving up sources of tips, and how they come to publish their news in the first place. So I think he had one reason for coming forward for this, and that was to tell the truth. Other comments have said that this jury verdict is a setback for the Me Too movement, and I respectfully disagree. I don't think it is, because there are some cases where allegations are made that are unfounded. Now, let's not let us escape the fact that the jury heard all of this evidence in great detail for some 6 weeks, and they came to a verdict, a unanimous verdict, that the articles were defamatory because the allegations made against him were unfounded. And so in my personal view and opinion, what this verdict means is that sometimes there are false allegations made, and I've known false allegations made in my profession in the courts of England and Wales. When we have family hearings, there is what we call a Scott schedule, which is a list of allegations one party making against the other. Either the wife against the husband or the husband against the wife, and they set out what they say are their allegations. And sometimes they are particularly serious, particularly heinous, and in great levels of detail. However, in many of those cases, the courts have found that these are not founded allegations, and the court makes a finding of fact that they are indeed false. Now, many of you will know that I am not quick to talk about my cases in any great detail, and certainly wouldn't give out anything to compromise confidentiality. However, I do feel it necessary to say that I've been instructed in one such case on behalf of the husband in the relationship, who produced a significant amount of evidence of injuries, including head injuries, face injuries, with a significant amount of blood, and lots of medical records to show when he went to get those injuries checked and treated. But there was no evidence the other way round. There was no evidence to suggest that he was the violent one within this relationship. However, when we got to court for the first hearings, the arguments from the opposing solicitors was to put my client on the perpetrator's course and their client into victim support, which in my honest view of all of the evidence that we'd seen at that point was completely the wrong way round. So I do think that when approaching these cases, it should be taken on the evidence, and the evidence should determine the views. On a completely different note, another question came up about home insurance and whether that can cover your legal fees. Now, anyone that I talk to, not that I provide investment advice or insurance advice or anything like that, I do say that if you have home insurance and the option to tack on insurance for legal fees for £30 or £50, £60, even £100 or £150, I would say it is very well worth doing so, because you can spend more than that in your first hour with a lawyer if you need to go and take legal advice or representation. Home insurance for legal fees, this is not a sponsored video, I'm not mentioning any names, can provide you with a typical £100,000 cap for legal fees for claims, which can span a wide range of different things, including family matters, including negligence matters, medical matters, public liability, all sorts of different things. But of course, always read the small print and always check out what's offered, because it can be worth it, but it's usually capped. And there may also be a clawback if you're found to be fundamentally dishonest. Those are known as fundamental dishonesty claims, where the insurer can then claw back the money that they've paid you. Typical examples that I've been instructed on in the past are where there's a claim on, say, pet insurance, by way of example, and the claim is found to be fraudulent. And by fraudulent, it could be something that they already knew about, but they told the insurer didn't exist. And it later transpires that it did exist. They lied to the insurance company. It was fundamentally dishonest. And then the insurance company comes back to claw that money back, having spent out £10,000, £15,000 and so on vet fees. So make sure you are honest with the insurance company and all should be fine. But again, I hope that should go without saying. So without making the video too long, those are some of the questions that have come up for my views and so on. Make sure you subscribe if you want to hear more, and do drop your questions and your comments below, because I'll make more of these videos, because there's a lot to talk about and too much to get into one video. But in the meantime, thank you for watching.